Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. As you know, if you've been following this continuing series on the Idaho versus Kohberger case, where we have been discussing the court filings going back to the very first filing of December 29th, 2022, you know that we provide our opinions here pursuant to the United States Constitution, Amendment Number 1, freedom of speech and of the press, which we will continue to do in this episode and all future episodes of this podcast. We have previously noted that according to Judge Stephen J. Hippler's October 9th, 2024 pretrial and trial order, under a section entitled D as in David, Trial Materials in bold lettering, paragraph 2, that proposed jury instructions shall be filed by April 14th, 2025. And if you read this order, ladies and gentlemen, you will see nothing saying that the jury instructions proposed were to be filed under seal. Unlike very differently, the proposed jury questionnaires, which is something entirely different. It appears in the first paragraph under trial materials, and it says right there that the proposed jury questionnaires shall be simultaneously filed under seal by March 24th, 2025. Well, the proposed jury instructions are not questionnaires that the good citizens of Ada County will be required to fill out after they're summoned to the courthouse for possible appointment as the 12-member jury and any alternates. These jury instructions are purely legal documents. This will be read to the jury, instructing them how the law operates. For example, providing legal guidelines as to what reasonable doubt is and is not might be one. Another might be the jury's role as the trier of fact versus Judge Hippler's role as the trier of law. These types of standard jury instructions are disseminated by the Idaho Supreme Court and are available for you to review. We have gone over a few of them in the Indie Zone YouTube channel. So these are legal guidelines. Undoubtedly, two of them are going to be what elements the prosecutor must have brought forward evidence to meet the burden at the beyond a reasonable doubt evidentiary standard, that sufficient evidence was brought forward during the trial to meet every element of the charge of first-degree burglary. That's not a secret. The indictment has been out since May of 2023, charging him with that count 1. Same with the counts regarding the unalivings of the 4 students. First-degree unaliving. No secret that that's what the grand jury charged Mr. Kohberger with, and these are the charges that he's standing trial for. So what confuses me is that while the parties did file their jury instructions proposed on the deadline of April 14th, and you can read them on the docket, they also filed motions to seal their proffered proposed jury instructions, and the court order granted those motions. So all of the jury instructions proposed that have been submitted to the court for his consideration are under seal. And my opinion, I don't understand why. Why wouldn't standard jury instructions regarding what the state must prove in order to sustain burden of proof under the charges that have been brought against Mr. Kohberger, why isn't that public? The law is the law in the state of Idaho as to what must be shown. I'm continued to be perplexed by the secrecy of this case. I don't know why, for example, if there was something that was sensitive and needed to be withheld from the public, why that 1 or 2 or how many proposed jury instructions could have kept under seal, but the others, such as reasonable doubt, such as the charging instruments and what the jury must find legally in order to render a guilty or a not guilty verdict, why is that under seal? We will continue to monitor the docket for further filings in the case. Until next time, this is Kathy. Thank you for joining us here today.